Hey, deserving listeners, if you have been paying attention to my reaction videos to the trial, you will notice that I will frequently be wondering about the legal aspects of the trial because I'm not a lawyer. I know a little bit about these sorts of things, but not nearly enough to know what's going on. And so I had some lawyers, attorneys who actually started emailing with me, and I thought I would have attorney Allison on the podcast to answer questions regarding the trial. I put out the word for y'all to submit questions, and so we're just going to go through those questions. They were great questions. I'm so curious as to what your answers are, Allison. Welcome to the podcast, Attorney Allison.
Thank you so much.
Before moving forward, though, Attorney Allison wanted me to say that nothing Attorney Allison says constitutes legal advice and should not be relied upon as such. You should always consult an attorney in your state to talk about your specific situation and any legal questions you might have. So, first question, do you agree with the verdict?
I think there was plenty of basis for the jury to reach the decision that it did. If I were on the jury, I probably would have returned the same verdict as they did. It would be fine if it had gone either way. I could see legal bases for both of those things. But from watching the entire thing, I do what came out.
What would have been the justification for having it go a different way, as you say?
Everything, I think, came down to credibility and how the jurors looked at the credibility of all the witnesses. So if you looked at Amber Heard and you thought that either she was believable or that enough of what she said was believable in terms of various kinds of abuse, that obviously would have made a difference. If the jury took a much narrower reading of both the law and the statements that were made in the Washington Post article, that obviously would have made a big difference. I think that's the reason why attorneys generally thought Johnny Depp had no chance in the beginning of winning, because the standard is just so high in the U.S. for a public figure in a defamation case. But I mean, they could have read domestic abuse as verbal abuse and could have won. They could have said, okay, we don't think you actually were domestically abused, but you were a representative of domestic abuse because you said you were. And so people looked at you as that. I think the only one claim that may have survived even with that narrow reading would have been the first statement, which is the essay claim, because she actually hadn't made any essay claims at that point. So that's the only one. I think that even if you were taking a very, very narrow view of what the statements meant and what the law legally allows, that one still could have gotten through.
Do you think that they thought that she was just lying about everything or enough things that they just threw everything out? Or were they reading it like, well, okay, verbal abuse, sure, but that's not really what she was talking about in that article?
I'm not sure if you saw, the Good Morning America said they had a juror that they verified was a juror. That was yesterday, I think, who came out, and who knows if this was a juror. And jurors, they can say they're speaking for an entire jury, but really they are only speaking for themselves. But I think they didn't believe what she was saying on the whole. I think that they thought there was verbal abuse. I mean, we heard there was verbal abuse. I mean, what I would consider verbal abuse, I know you would consider it verbal abuse, but that isn't what she was talking about. She wasn't saying, I was verbally abused by Johnny Depp when she went to get a TRO in 2016. And everybody knew that's what she meant. So even though you can parse the words domestic abuse to mean all these other things, and their attorneys tried to do that. Johnny Depp, isn't verbal abuse abuse? Yes. Isn't psychological abuse abuse? Yes. That's not what she meant. And you can argue all the technicalities you want, but it's just really a common sense kind of person. It's not a legal thing when it comes down to, look, we know what you were saying, and we don't believe that that happened. I think she did no favors with her to her credibility while testifying, especially, I mean, the donate versus pledge thing, she didn't have to do that. She could have just owned up to it and said, you know, I made a mistake. I misspoke, whatever. I wanted to do it. I thought I was about to do it, but I couldn't for whatever reason. But her reasoning was ridiculous. There's just no excuse for trying to make that analogy to the mortgage. I think you lose so much credibility with the jury when you can't even admit that. It's so black and white.
A lot of people had questions, and I did too, about maybe along those lines what the strategy was behind the scenes between the legal team and Amber Heard, because we have to assume that there was a lot of discussions and practicing and coaching, or at least advising. And when we see Amber Heard's behavior on the stand, the looking at the jury, the way she responded to the questions, and there were multiple moments where it was like that. The other moments where you're like, just admit it, just say, yeah, that happened, but that doesn't mean that I wasn't abused. So do you think that the legal team signed off on the things that she was doing, or did they actually advise her to do that, or was she going rogue, or did they not prepare enough? Like, what do you think? Of course you don't know, but given your experience.
If I had to guess.
Yeah.
I mean, she has locked herself in so long ago on what her story was, going back to 2016 when she did her first deposition in the divorce case. She's had to try to maintain a consistent story well before she knew any of these lawyers. She had the UK case. I believe Elaine represented her in that case. Not positive about that, but I'm pretty sure. But I get the sense that she's that she would be a client that would really be into driving the bus herself. I think she probably got plenty of good advice from her lawyers. And a lot of what we saw, I think, is just who Amber Heard is and how she might talk to people and what she thinks is convincing. And if I had to guess, I would say that her attorneys definitely would not have advised her to never admit anything, never give on anything, because these people know what they're doing. This is not their first rodeo. There's a reason she hired them. I think that if I had to read Amber's mind and know who she is, I would think she feels like she cannot admit she's wrong, whether it's because then people will doubt me on everything else, or because she has this image of herself that she feels like she always has to portray perfection or something like that. So I don't know if they said sometimes look at the jury a little bit. Usually that's something we see more with expert witnesses because they're actually supposed to be explaining and teaching the jury what they're talking about. But usually it is more of a conversation between the lawyer and the witness. And I think that may have made the jury very, very uncomfortable when she would stare at them, especially when there was a sidebar or something and it was a very extended sidebar and she would literally turn her chair, or not even turn her chair, but like turn her face and just sort of stare at them to see just checking their reactions. On the GMA article, alleged juror said that made them uncomfortable. It would have made me uncomfortable. But I think that her lawyers were giving her all of this bad advice? I don't think so. I don't.
Could you imagine them behind the scenes or during the break saying, "Hey, Amber, like I get that you're looking at the jury, but just keep eye contact with me because I think it'll go better for you." Could you imagine them saying such a thing?
Yeah, I mean, she's technically not supposed to speak to her attorneys about her testimony while she's still technically under oath.
Oh.
So that's not supposed to happen. Is she allowed to go on social media because she is a party? Yes, she's allowed to go on Twitter and see what everyone's saying about her. And she goes, and I'm positive that she saw people saying she was overacting. And you'll see on day 2, she did pull it back a little bit. But maybe they told her, if they felt that there was an ethical way that they could tell her, hey, you might want to pull it back a little bit in terms of I don't want to call it theatrics because I don't know if in her head this is all real, but theatrics. If they were allowed to talk to her in between days of testimony and it was an ethical thing to do, I certainly would have told her to stop doing that. But this is, again, it's not her first time testifying. She testified in the UK. And so to some extent, the lawyers had to know what they were dealing with at this point.
Her demeanor in the recorded clips that we saw was so different than her demeanor in the U.S. trial. She seemed more natural, but also combative, angry at times. I mean, I don't want to be sexist and say, oh, she's an assertive woman, therefore she's being bossy or something. But she had at the very least, she was more assertive, if you just want to put it in a positive way. While in the U.S. trial, she was way more like fragile or something. Is that how you read it?
Oh, for sure. I mean, she sounded like two different people. That was another thing that I would assume that the jurors just felt didn't go together because she's saying, I'm so scared of him. I was afraid for my life. I had to tiptoe and walk around on eggshells around him. And she's screaming at him and telling him to do this and don't leave and you can't do that. And you're such a terrible father. It doesn't go. I mean, I never want to say this is not how an abuse victim would act, because how would I know? And there's no uniform way of doing that. But again, it's just, if that had been consistent with how she was on the stand, then that would go together. And that could be how she is. If she in the recordings was more fragile or submissive or whatever you want to call it, then that would go together. But the two separate things don't go together. And that, I think, strikes everyone as not real.
If you were her lawyer in the courtroom, would you be cringing on the inside and trying not to show it to the jury?
Yes.
What would you be thinking?
What have I gotten myself into? How can we turn this around? I don't know. It is so tricky because you're not supposed to talk to the witness once they're sworn in. I mean, you notice that they had Ben Rottenborn questioning her on the rebuttal and not Elaine Bredehoft. I think his demeanor was meant to be more calm. Let's not go crazy. Let's not go over the top. That's my guess. And that he could sort of keep her in line a little bit more in terms of answering the specific questions. But yeah, I can't believe they kept her up there for 4 days on direct. I have no idea why they would do that.
Meaning that you think they should have pulled the plug earlier because they were shooting themselves in the foot?
Well, they're using up all their time on her, for one thing. At the end of the trial, they had no time left, especially on rebuttal. They didn't have time to cross their rebuttal expert, Depp's rebuttal witnesses, and they just ran out of time. So that was one thing I thought was not smart. But if your client is your own weakness in your case, don't have them up there as forever, like for 3 days before that long break, and then, or 2 or 3, I can't remember. And then 1.5 days when you get back from the break. It was just a lot. I feel like they could have moved things along more quickly in a way where there didn't have to be a 30-minute story that was a bit unbelievable and still made it through everything. It was just a lot of Amber Heard, a lot. And a little bit of Amber Heard is a lot of Amber Heard to me.
Yeah. So there are a lot of questions about Elaine. Rando emailed in and said, I'm confused as to why an experienced and well-respected lawyer like Elaine would take on a lying client and flush her career down the drain. Why would she do that?
Well, for one thing, I don't think she's flushing her career down the drain. This was one client. This was one trial. We've all had bad clients. We've all had bad outcomes. She had a good career before this. I'm positive she'll have a fine career after this. But what would make her taking on a lying client? For one thing, I don't think she, at least in the beginning, I don't think she thought she was lying. You generally don't want clients that, during the intake, you think, oh my gosh, you're a complete liar. That's not really that fun to represent someone that you think is lying.
So would that happen? I mean, I'm guessing there's a variety of reactions from lawyers regarding that, depending on how much they're getting paid. I mean, I don't want to say something that's not true, but I could imagine someone saying like, well, 1, this is a big payday. 2, I could get some notoriety because I'm likely to win because the UK
That's
trial
true.
won. And even if I do believe, I don't know if this is so truthful, this is a good gig, I'm probably going to win. Because as you were saying, most lawyers thought Johnny Depp was going to lose. So Elaine taking the case was a smart thing, probably. But if you were to have someone come into your office and you were like, I'm 90% sure, not only that this person will lose. Well, let me ask you a more kind of tricky question. If you thought someone was going to win, but you were also pretty sure they were lying, would you take the case?
If they're lying to me, no, because you have no idea what wild card would come up. In this kind of a case where it is an individual, it's not a corporation, it's not a criminal defendant who has a right to counsel. Not that you have to represent anyone who comes to you if you're a criminal defendant, but if they're lying to me, you don't know what you're going to get with that client. And I mean, different lawyers obviously will have different opinions on this. I would not want to be spending years and years of my life embroiled in a case where I thought my client was lying.
So you would just say what? Like, I'm sorry, I don't have time in my schedule, or what
No,
would you
I
say?
would say no. Just she would have shopped around a lot of lawyers. I'm pretty sure she did have several attorneys. I think Elaine was the longest one, but I think Rottenborn was relatively new and he's from a different firm. But you can always just decline a client. That's pretty normal. Like, I don't think it's a good fit.
She has to pay for her legal fees, right?
Yes.
How much do you think that was about?
Well, I mean, someone, I believe it was, she mentioned $6 million on the stand.
Wow.
That seems pretty high.
Was Johnny Depp's team more expensive, do you think?
I know Brown Rudnick because it's a Boston-based firm that's national. So I would imagine that they are more expensive than Elaine's and Ben's firms because they seem to be smaller local practices.
Listener Everett says, was Elaine's conduct during the trial considered normal within the U.S. legal system? For example, the mocking and the leading questions.
So the mocking, no, that was not okay. It was unprofessional. I don't think it was unethical. I think it was unprofessional. The leading questions, I assume the direct witnesses, that's not normal to be so poor at questioning. And if you're a trial lawyer, and again, I don't know how many trials she's done. Some people think that just because you're a lawyer, you do trials all the time. That's definitely not the case. But she was particularly, in my view, not strong in questioning, whether it was direct or on cross. But yeah, it was not good. And I saw when she came up for redirect a few times, maybe it was with Amber, that she had her legal pad. She must have written down like some points she wanted to hit, but I could have just missed it. I didn't see anything printed out that she had plenty of time to know the things she needed to get out on redirect because she'd been crossed for a day and a half. And to not have just written out the questions, if you know you've had such a hard time doing direct examination, that was surprising to me when I saw that she just came up with the legal pad. She's flipping through at the very end, which she can't get any questions out without objections. And then she just gives up and says, I don't have any more questions. It was just odd to me that it just did not appear that there was as much preparation just on literally writing up the questions as I would have expected.
Do you think it was lack of experience or being flustered or feeling like she had to scramble because she might have been predicting at that point that things weren't going well? What do you think was going on there?
I have a hard time believing it was a lack of experience because I have a hard time believing that Amber Heard and the people who would have been advising her would have hired someone to go to trial with her who doesn't have a lot of trial experience. It's possible that in other cases, she's just had an easier time. I think she got flustered a lot because Amber, it seemed like, would go off on tangents or further than the bounds of the question had been intended to go. And so I think to try to get her back on track and say, no, remember, this is what we were supposed to talk about, she'd ask the leading questions to get her reoriented back to that. And that's when Camille would object because you're not supposed to ask leading questions.
Yeah, I mean, as I was saying earlier, I'm not a legal person, but eventually even I was saying, well, that's going to be sustained because that question was ridiculous.
Yeah.
I mean, she would literally just state something and say, do you agree with that?
Yeah.
And I knew enough by that point that wasn't okay.
It was annoying because she's already said it by the time there's the objection. So Amber knows what the answer is supposed to be to the whatever vague question she asks next. So it's kind of an end run around the whole you're not supposed to lead a direct witness thing. That's what was so frustrating to me. Or that was one of the things I should say that was very frustrating to me.
Oh, really? So you're watching and you're like cringing and getting frustrated?
Oh, yeah. I mean, I think lawyers tend to do that anyway. Like, oh, I would have asked this question this way, or why didn't they ask that? But when you ask a leading question like, Amber, didn't you go see an ENT after your relationship with Johnny Depp because you had scar tissue in your nose from a broken nose? Yes, objection. And then she asked the next question, and not in that particular area because that whole line of questioning was sustained. But when she asked the next question, Amber can just say exactly what she had just said in the prior question. And it's just frustrating to have them get away with that because it kind of makes the rules meaningless.
Do you think the judge was biased? Some people think that the sustained, overruled rulings were one-sided. What do you think about that?
For one thing, I don't know that they were one-sided. If they were one-sided on Amber's testimony, it was because Elaine's questions were so bad, and Camille was very good at objecting. There were a lot of questions that the Depp team got that were sustained objections on the other side. Do I think she was biased? I have no idea why. I mean, I guess if you counted up the objections, maybe there were more on one side that were sustained than the other. But I disagree with that. But I can't understand why anyone would say she was biased. It seemed pretty down the line to me.
Do you think the judge did a good job?
I thought she did a very good job. I think most lawyers really did appreciate her demeanor, the way she treated the witnesses and counsel. I could never tell one way or another, really, like, I hate this side, I really like this side. I think her hearsay definition is overly broad, but I thought she did a great job. We've seen judges in a lot of public trials in the last few years where they have not been, I think, as kind or professional. And I thought it was a good look into seeing how a judge in the justice system can be seemingly fair. I mean, I guess if you're on Amber Heard's side, you think it might not be fair. But for the lawyers, I think that generally we think she did a good job and that we would like to practice in front of her.
Chris from Britain asked, will Elaine's conduct after the trial possibly result in punishment or disbarment?
I assume that's referring to her comments about the jury possibly seeing social media.
Yes.
No, I don't think so. I mean, they're going to appeal, and I'm sure one of the bases for that is to say that Amber couldn't get a fair trial because the jurors saw social media, because there were cameras in the courtroom. Social media was just plastered with coverage of this case, and so it was inescapable. It's going to be in their appeal. It's talk about litigation. There's nothing I can see that she's not alleging specific juror misconduct, but no, I don't think she's done anything that would get her in trouble.
Another question from Rebecca says, did seeing the criticism Amber Heard's lawyers got make you feel different about the prospect of representing celebrities in the future?
I don't know that it would change anyone's view if they already had a practice that would cover those kinds of cases. Would I want to be in that kind of limelight? No, especially if there was a camera in the room, because you are going to get picked over by everybody. But for the people who are in that space, who practice in that space, I don't think it would. I think they probably think that they could do a better job than Elaine.
Patron Marta from the Netherlands asks, can Amber Heard face charges for perjury?
I mean, anyone who lies on the stand can, in theory, face charges for perjury. If I had to guess, no, she will not be charged. Judicial resources and all of that, is this where they want to go, especially since there's going to be an appeal. So this is not really going to be final until an appeal she's exhausted all of her appeals. I have no idea how far up she's going to go. So by the time this is finally resolved, however many years later, no, I don't think that Virginia prosecutors are going to want to prosecute her for perjury. It's disappointing, and I know it's really frustrating to a lot of people that someone can just go lie, assuming that she lied. But yeah, it actually rarely happens.
Yeah, I think that's the place that these questions are coming from, is the shock that, wait, so you could just lie blatantly on the stand and even be, in a sense, found to be lying on the stand by the jury and just get away with it? Like, I thought on the TV shows you couldn't do that. Yeah, that was against the law.
I mean, yes, it's definitely against the law, but we have to remember that this was not a criminal case. The burden of proof was only a preponderance of the evidence. So it's not as though a jury found that beyond a reasonable doubt she was lying. It was preponderance. So that's a completely different standard. A prosecutor would have to prove beyond all reasonable doubt that she absolutely was not abused at all. And it's really hard to prove a negative.
So the preponderance, from my forensic psychology days, I think I remember hearing that's like a 51% assuredness.
Yeah, more likely than not. Yeah.
Yeah. So the jury was saying, we're 51 or more % sure that defamation occurred to Johnny Depp. Yeah.
Yep.
Lori says, what are your opinions on grounds for appeal? Is her attorney bluffing?
I mean, I think she'll file an appeal. It's not hard to file an appeal. I think the grounds of appeal would be the biggest one they're going to argue is the evidentiary rulings about what came in and what didn't come in. They've been going on about the therapist notes that they say it wasn't officially admitted in evidence. It came in through Dr. Hughes, though. So they argue that a lot of stuff was kept out that should have gone in. I assume that's going to be most of their bases for appeal. I think the social media / cameras in the courtroom thing is going to be the other big issue. Other than that, when you have a jury verdict, it's different than when you have a bench trial and the judge is deciding it, because the judge will write a really long opinion going over his or her bases for making the ruling, the findings of fact, how that applies to the law. And you'll have a ton of stuff you can pull out and say, oh, this was wrong, and appeal those things. You don't know that with a jury. You have no idea why they came to the conclusion they did, so you can't pick apart their bases for the judgment that they came to. But if I had to guess, those would be the big things.
Well, with the jurors coming forward, potentially, at least one so far, does that put the possibility of an appeal going through higher?
So the rule is, and I believe this is true in Virginia, and it's definitely the federal rule and most states' rules, is that you cannot take post-trial statements of a juror into account. You're not supposed to look into the, quote, mental processes of the jury or any particular juror when they just don't reopen that. The only thing that would come into play is if they found out that a specific juror was influenced by someone who was talking to them, if there was a threat made against a juror, if there was something big like that actually affected what the jurors knew that they weren't supposed to know. But it has to be really, really concrete and direct. I'm remembering one case where it was overturned, and it's very, 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 very rare. But one case that the jury verdict was overturned was when there was some crime that happened and an eyewitness was in this store, and the defendant's motorcycle ran in front of the store during the crime, allegedly. And so the juror went to that store and sort of did their own experiment about how that would go, and then came into the jury room and told everybody. And then another juror went and did the same thing. That's not what they're supposed to do. So that kind of a thing can be the basis for a strong basis for an appeal, but not just, oh, this juror said. I mean, one statement that jumped out at me in reading the GMA article was when the alleged juror said, we thought that the abuse was mutual, that Johnny Depp's was not physical. When I saw mutual abuse, I mean, if I were Elaine and Ben Rottenborn, I would say, aha, they said it was mutual abuse. That means he abused her, and you can't say that verbal abuse is not abuse. So would they probably put that in there? Yeah, I guess, since appeals in this case, are going to be as much about PR as it is legal. So I think it's very much about saving face. And that's the reason also that I think Johnny Depp is not going to want to do anything more. People have talked about on the internet, maybe he should reopen his UK case now that we know she lied about the donations and things like that. I say go out while you're ahead. Why would you've got this giant win of 7 jurors who found unanimously that you are not an abuser and your ex-wife was. Why would you want to take a risk to get this marginal victory when essentially you can say you're 7-1? Why would you want to risk the chance that the next judgment would be against you, and then that's the end of the line? So I think it's flip sides of the same coin.
So the mutual abuse statement by the alleged juror, that seems to be in that category of getting inside their mind, because even if that's true, you would still have to say, well, then he must have, or even other jurors must have said, well, yeah, there's mutual abuse, but what she was claiming in the article wasn't referring to verbal abuse. And so that's why we found the defamation to be accurate. So isn't that right? Am I right about that?
No, that's absolutely right. So that doesn't mean they won't put that in their appeal or their brief. They can argue that. They will lose, and I'm sure they know they will lose on that. That doesn't mean necessarily, especially when a case is as much about PR and how the public is viewing you and seeing your arguments that doesn't necessarily mean you wouldn't put that in a brief.
So even if the jurors came forward and said, yeah, I mean, we thought that there was a good possibility that he was abusive to her, but we just didn't believe anything she was saying, so we ruled against her. Would that stand?
Yeah. I think unless you have a juror who some Johnny Depp supporter called him up and said, I'm going to harass you or your family, or someone comes over with a pile of newspaper clippings and says, read all of this stuff. Or we find out that a juror was explicitly doing research, like looking up all the UK documents and things like that. Absent any of that, they're not going to be able to say that the jury, however they thought about it, was wrong.
What if one of the jurors says that they let it slip that they actually did look at social media, but they don't disclose what they looked at? Like they're like, oh yeah, there was one night when I watched a bunch of stuff on YouTube, or I was looking at tweets about the trial, but I didn't let it get to my head. Would that be grounds for a mistrial?
I mean, anything, you can try to argue anything. Obviously the devil's in the details, but I think you can still find, it still has to be prejudicial error, reversible error, essentially, that it has to be not just that, oops, I saw a TikTok or something on Twitter. It has to be such that either the trial judge or an appellate judge would say, okay, this was a big enough deal. This could have actually affected the jury's decision. So not every single thing like that would be successful grounds for appeal. Again, you could put it in there, but I don't think something like that would be likely to sway a judge or a panel of appellate judges, something that small. I mean, again, it depends. Are you sitting there for 3 hours every night looking on purpose? Yeah, that's probably not good. And that could be a problem. I would have a hard time thinking that that would happen, but it's somewhere between I saw one tweet and I spent 3 hours every night looking this up on purpose.
Wouldn't it be hard to resist, though, with all of the social for that many weeks? I mean, how was it, like 6 or 7 weeks that this was going on?
It was 7 weeks total if you take into account the break. Yeah, I mean, it would be hard. I know that this alleged juror said that 3 of them didn't even have Twitter, which is kind of interesting because that's saying the rest of you did. And they didn't come out and say we never looked at social media at all, or that we never saw anything about them at all on social media. I have no idea what people's Twitter feeds look like that weren't already looking at this to begin with. So do I think that they saw some things? Probably, yeah. Does that mean that they're going to stop believing Amber Heard all of a sudden when they just saw her for 5 days on the stand doing what she did? I don't think so. But again, I can't be in anyone's head.
So I keep wondering about the way they will look back at this trial in 20, 50 years. And the one angle that I'm imagining will happen is that the O.J. Simpson trial was the trial of CNN or of television news, because it was the first televised high-profile case that people were riveted by and watching every day, but it was on the television. It was on broadcast TV. And the Amber Heard Johnny Depp trial is the first trial broadcast on the internet that everyone was paying attention to. And the added layer of mainstream media and non-mainstream media outlets, which I guess you could consider me to be a very small part of, and how it will be a landmark example of that moving forward, of other cases that will have a similar feel to it and legal realities that have to be accounted for. Future judges are going to think about this trial as to whether or not they should allow it to be televised or not.
Mm-hmm. Yeah. It's tough to say. Obviously the choice to televise it impacted a lot of things. It's so hard to know what was the right decision versus the wrong decision, when it's appropriate to have cameras in the courtroom for these kinds of things. I know that the judge, when she was saying that she was going to allow them, she was worried that if she didn't allow there to be something in the room that could tell everybody what was going on, that the courthouse was going to be inundated with media, with people trying to figure out what was going on and literally actually disturbing what was going on there, that the jury would see that creating more of a circus just so that people could know what was going on. And that was, I think, her big reason for saying, okay, fine, we'll just have one camera. Everyone will get everything from there. And there was only one member of the media, I guess the mainstream media from Court TV, there the entire time. So I guess to that extent, it did work. But yeah, I think it's still rare that we have televised trials, especially for ones that are not the big criminal trials. I think it might end up being the way it is moving forward. If one of the parties wants to do it, there's a big interest in transparency in the legal system so that people are supposed to, because it's transparent, have faith in the legal system. It could, go either way. But this may just be the way it's going to be. Do I think they will televise all cases? No. It may only apply to a few cases. If you're thinking about it, it's not that often that one celebrity sues another celebrity for this kind of a thing. So I don't know. I think, the Ahmaud Arbery trial was televised. Kyle Rittenhouse was televised. I think for certain criminal cases, it's really important actually for people to know what's going on. I don't know what Judge Ascarati thinks about whether she made the right decision on this or not. So I don't know that answers the question. I think it's a huge question mark, but social media is gonna social media and that's not going away. So yeah, tough to know.
Do you think that was a bad thing that it was televised and that it was and social media was involved?
I'm probably a little biased because I wanted to watch it. So do I think it was a bad thing? You could look at it from so many different angles. I understand Johnny Depp's position for wanting there to be cameras in there because he feels as though she told her story to everybody already out in the media. So he wants his story to get out, whether or not he wins or loses. There is a public interest in open access to the legal system. Again, it really comes down to did the decision to have a camera in the courtroom and have social media all over it, what impact, if any, impact did that have on the jury? And without knowing anything more than we know now, I don't know that it made an impact on the jury. So from that point of view, then no, I don't think it was a bad thing.
Do you think that they should have, sequestered maybe is the word for the jury? Should they have done that?
That's so rare even for criminal cases.
They did it during the O.J. Simpson trial.
Yeah, for criminal cases, and that's rare. And I think that people look back on that. I think Marsha Clark looks back on that and thinks that was a bad idea in retrospect, because when you have jurors sequestered for, I think that was 250 days or something.
They're miserable.
They're miserable and they want to get out of there. So they're going to make a decision as fast as they can. They might just acquiesce to the majority. I think that sequestration is generally a not good thing. It's extremely disfavored. It's so rare. It's so expensive for courts. It's not good for jurors. These people are getting paid $30 a day, not being able to see their families, not being able to use the internet, not being able to go out in public. I've never heard of it happening in a civil case, and I'm sure it has. I just don't know of any time. It's not someone's liberty involved in terms of are they going to go to prison or not. It's a lot of money, sure, but I think if you balance that against the liberty of, I think it was 9 jurors that were initially listening to the whole thing. Yeah, I don't think either side wanted that either. I don't think either of them asked for that.
Tegan asks, do you think the verdict would have been different if it was decided by a judge?
Yes. Do I think it would be different? I don't know. This is the answer, of course. But do I think it could have been different? Sure, because judges tend to focus, because it's their job, much more on the law and technical aspects of the law. And I think it would have been easier for a judge to say, I'm going to look at these statements very narrowly, just with a narrower definition than a broader domestic abuse, even though there might have been some verbal abuse. I have no idea what she thought of the case. But do I think it could have been different? Sure. There's a reason that all the attorneys, or I shouldn't say all, a lot of the attorneys before the trial started thought there was no way that Johnny Depp would win. So it's very possible. But again, then you see the witnesses, you see people testify, and Amber did not do herself any favors. But I think that there would have been a much higher case that she would have won if it were a bench trial.
You might have already stated this, but do you think Amber Heard was lying?
Yes. I mean, about some of it, certainly. I can't.
What do you think she was telling the truth about of the most important details?
Of the most important things. I mean, I think she was generally telling the truth, on the big picture level in terms of his substance use, in terms of his maybe breaking things and yelling at her. I think that he probably was very jealous in terms of being worried that she would, have an affair with her co-star. And I think a lot of people would say that those were not unfounded worries. But I think that, and again, I know some of this that wasn't presented to the jury, but just stuff that from reading things, that he had shown some jealousy with prior partners. So I think on those things, I could totally see that being the case. I mean, he admitted to some of it, but I'm trying to think of if there's anything else I think she was telling the truth about.
Do you think he ever hit her in the face?
You mean initiating or?
Well, either.
I have no idea. I mean, if we're going on the instances that she talked about, that she specifically identified, no, I don't think that he initiated any of those things.
Meaning it was defensive if he did hit her in the face.
I think he ever hit her defensively in the face? I have no clue. He says he never struck her.
So you think it's possible that he never hit her in the face or headbutted her?
No. I mean, I think that the headbutt thing happened. I think he maybe didn't characterize it as a headbutt.
Yeah.
But he admitted that something like that happened. And I think of the pictures that she provided, that one incident was the one that looked the most like, I guess, what she was saying. I mean, it definitely didn't look completely like what she had described, but it looked the most legit or believable.
And the bruise on her cheek, like the side-by-side photograph that was clearly the same photograph with a filter that she was claiming was taken at a different time.
Do I think that was real?
Well, no, everyone understands that was not two different pictures. Anyone with half a brain cell understands that those are the same gosh darn picture. But there was an alleged bruise on her cheek that she claims was the result of him hitting her. So you think what do you think that was?
On that incident, I think that was the May 21st one.
Yeah.
No, I actually don't think that was real. And I think that that's a really easy thing to do with makeup. Honestly, when she did the one in the lighting that was brighter, I couldn't really see much. When you alter it, yes, it can look different. But I did my own experiment at home with Gel blush just to see, and it was really, really easy to do. So I don't know I don't know what happened.
Was your partner going, what are you doing?
I don't think he was around when I was doing it. And of course I washed it off soon after because it's kind of embarrassing to be doing, but it wasn't hard. So I have no idea if she did get hit in the face with a phone, but I did not find believable.
What do you think was going on when we see the testimony? The picture, for example, of the nose bruise, which looks legit, but her claim was that he beat her repeatedly, dragged her around. There was broken glass, blah, blah, blah. I don't know if it was that incident, but every time she talked about being beaten, it was extensive over.
She got hair ripped out on that one, allegedly.
And she was beaten to unconsciousness, not just for a few seconds, but for, I think, hours. Mm-hmm. What do you think is going on in her mind when she is testifying, and or the lawyer's mind? Because they must have gone over that story, right?
Yeah. I'm sure she has been prepped for days and days and days. I mean, that's just normal to do with a witness, maybe not days and days and days. But when someone's going to be on the stand for 5 days, they're going to be doing this a lot.
And they practice cross-examination stuff.
Oh yeah, and direct. They'll do both, and that's totally fine. And it's hard to do direct examination or cross-examination, so you do want to practice it, make them comfortable, make sure they understand what they're supposed to be getting out, and how to answer the tough questions that you know that you will be asked. But what do I think was in her mind when she's telling that story? I mean, I can't recall what her story was with the UK case. It's got to be tough to remember every time you've ever told the story. So if we're going back to whenever the first time was that she told the story, my guess, and again, totally a guess, is that she thought that just the headbutt incident when he was supposedly grappling with her didn't sound bad enough. And so she just kept adding on and on to make sure everyone understood this was really bad. That's my guess.
And then she had to uphold that later on because
you can't go backwards. And she had some inconsistencies, I know, with her testimonies in the different trials.
And she tried to get out ahead of that by saying it's been a while and she doesn't remember the exact sequence. She would try to say that. But I didn't know that. So she had to adhere to statements she made 6 years ago when she didn't probably have good legal representation and was just saying stuff off the top of her head, thinking this will never come back around to me. And so she was completely beholden to that story, because if she doesn't say that, then they'll bring it up and say, you're contradicting yourself, and the whole thing gets thrown out, right?
Yeah, so what I think happened, and we only have that one tiny clip of her deposition in 2016 for the divorce case. The one where she says TMZ and then she does the face thing. And then the one where she's explaining the staircase incident. So I don't know how she said any of the other things. My guess is that they were actually at that point way, way less involved. And maybe she didn't even talk about all of them. She probably wouldn't have talked about all of them at that point. So I think the UK, when she was writing all the statements that they have to do and then testifying there, is probably when it snowballed. But yeah, you can't back off after that, because then Camille Vasquez says, do you recall being under oath in the UK case and saying this? And then that's a bad position to be in.
So if you're Amber Heard's legal team, you have to know this does not look good. That she has this picture of what looks to be one strike to the nose, a good strike to the face, but it does not match with the story that she's telling, when you add the rings in and all that kind of stuff. And as the legal team, you have to be, that's a pretty major bit, I'm sure, that they poured over extensively. You must be, at least in your mind as a legal team, going, this is not going to work. Right?
And I'm pretty confident that they would not have been telling her the risks of going to trial versus not, because that's what you do with your clients. You say, we could win because the standard of proof is in our favor on this, very much so. But here are all the problems with our case that either the jury will latch onto and say you lose, or the public latches onto and say you're a liar. I think that there might have been, I don't want to say egos on both sides for Johnny Depp and Amber Heard. I don't think this was never about money for Johnny Depp. So I don't think a settlement would have been particularly palatable to him unless there was a clause saying, Amber Heard, you will go on TV and say that you lied about this, which she's obviously never going to do. So I don't even know if they had advised her to settle this, if that would have even been possible. So I think they were stuck with what they were stuck with, and they tried to do what they could, saying that makeup is really good and icing hides a broken nose. I don't know. I think that was what they were stuck with.
Right, yeah. So they're probably thinking, well, we just have to get the jury to understand the foundation of the decision, which is if you believe that Johnny Depp was abusive one time, then free speech reigns, right? And there are some very dubious evidence that is going to be scrutinized, but that's not what we're talking about. The jury can still say, well, clearly those three stories are lies or exaggerated or something, but there's enough evidence to find that Johnny Depp was abusive at least one time. That was their argument in the opening statement. Does that make sense? Does that argument hold water?
If you want it to hold water, if you're a juror, then it can. I mean, you can decide on whatever basis you want. I think it's fair. I think it would be fine and perfectly legal for a juror to say, she experienced this one instance of domestic abuse, so therefore this, I'm putting aside the essay claim, but therefore these two statements in that article are not actually false, provably, definitely false. So I'm going to find in Amber Heard's favor. I think it's also perfectly legal and fine to say, we're going with the gist of what you meant when you said domestic abuse. And what everybody knew you were talking about, which was not there was this one instance of domestic abuse, and that's why you were the public figure. I think it's totally fine to look at it either way. That's what the jury system is all about. They don't have to all agree on the same theory. One person could say, if they found in Amber's favor, one person could say, I think one thing happened to you. Another could say, I think all of the things happened to you. One can think she's a liar, but pretty sure something may have happened to you. It all counts as the same thing in the end.
People were asking about legal precedent, and I think I know enough about legal stuff to know that jury rulings don't
not presidential.
They don't show precedent. Yeah.
Yeah.
Precedent.
Even if it were a bench trial court levels, they're not precedential on any other, even trial courts, but you have to be at an appellate level for it to matter.
Well, I mean, maybe a more broad question that a lot of people submitted was, does this change, or is this evidence of a changing landscape regarding the bar for defamation, the threshold for defamation?
So I don't think so. And I think the answer to your question was no, jury verdicts don't change the law. For one thing, this is specific to Virginia defamation law, but no, there's no legal opinion saying here are the reasons why we reached this decision so that you can even apply it in another case. So no, you can't go into court and argue, hey, this jury over there thought that was defamation, so ours is also defamation. So no, I mean, it's completely up to whatever jury you're selecting. Everything, it depends on the facts of the case. There's no such thing as an identical defamation case. So no.
Do you think that true victims are going to be more hesitant to come forward or to make it public that they were abused? That
I don't think I can answer. Again, I think that this is very removed from the situation where you would have a typical not famous domestic abuse victim who's going to the police and saying something and then nobody knows anything about it. It's not you're not publishing anything in the Washington Post about it. I mean, there is some standard that you have to show for defamation where it has to be published. Other people have to see it. There has to be actual damages to you. So I don't think most of those things will happen in quote unquote regular domestic violence cases. But could just the publicity of it and what people are seeing on the internet make people more scared to come forward? I couldn't say. What do you think?
I hope, I don't know, but I hope that this case actually raises awareness about intimate partner violence in general, and we need more of that. I hope that this raises awareness that men can be victims, which of course is obvious and well known in the research. I hope that this illuminates that it is possible that some people will lie as accusers. I'm worried, I guess when I say that out loud, I'm worried that this sets back women who will come forward because there is already too much skepticism to begin with. And that, of course, is not our fault. It's Amber Heard's fault if she was lying. She doesn't help that movement. But you said something interesting. So if someone was a victim, let's say of a famous person, and they take legal action, so there's that level, and you don't talk to...
Sorry, who takes legal action?
The victim, okay. Sorry. The victim gets a restraining order, or,
okay.
Say it's a spouse of a famous person, and they get a temporary restraining order, they go to the court, and they do all that regular legal stuff, and they don't go to the press, then defamation is not at play?
No, and there's a litigation privilege. I'm pretty sure that's universal across all 50 states, where statements you make in the course of litigation, you can't be sued for that.
Okay. I didn't know that. That's interesting. I mean, that makes a lot of sense.
For attorneys and the litigants.
So people that are trying to get safe and are trying to alert the authorities, this has nothing to do with that. It's because she went
Correct.
To the press.
Yeah.
Going up the ladder, if someone did that and they were legit being victimized by this famous person with millions of dollars and lots of lawyers ready to go if the victim steps out of line, so to speak, and they talk to a friend who tweets and says, my friend was abused, what happens? Could that be defamation?
I don't think that, again, defamation law is governed by state law. So every state may have different case law on it that I might not be aware of, but I wouldn't think that counts as publication. If you're just telling someone, they are actually the friend is actually the one publicizing it. And I don't think the friend could be sued for or successfully sued for defamation because they wouldn't be able to show actual malice, which means knowledge of the falsity or reckless disregard of the truth. It doesn't mean like malice in terms of, I hate you, I'm going to do this because I hate you. People get confused on that sometimes. But no, I don't think if you tell a friend and then the friend tweets something and People magazine picks it up, I don't know that you, the victim, can be
sued.
Anyone can be sued over anything, but I don't think they'd be successful in that.
What if you came forward and said you were a survivor of intimate partner violence 3 years after divorce and had this huge caveat that says, I can neither confirm nor deny who it was. I've been in 15 relationships in my life, but I'm here to stand with fellow victims of this crime and atrocity. Would that be more in the direction of because we're getting closer to what Amber Heard actually did at this point,
If the person is not saying that my domestic violence happened 3 years ago, like she did, if it's just, I was in this relationship with this famous person, but at some point over my life in the 15 relationships I've had, I was a victim. No, I don't think that, again, you can sue anybody for anything, but no, I don't think that would rise to the level because I don't think you'd be able to identify reasonably who it was.
Interesting.
And that was one of the jury, instructions on the jury verdict form was the statement about Mr. Depp. So I don't know how a jury would be able to find that. It was literally just limited to that set of facts.
Even if everyone just assumed it was that famous person, you took reasonable precaution to...
I mean, that sounds pretty reasonable to me to say. I'm not saying who it is. Just based on what you told me in that hypothetical.
Yeah.
No, I don't think that crosses a line.
Interesting. So it's just those tiny details in the statements in the publications that she made that if you just took out one or two words or a sentence here or there, it would have...
That's a good question.
Pushed it below the surface of the threshold.
It's the time frame was the issue. That's how people connected the dots. It's because she said, 2-3 years ago, I became the public face of domestic violence. That's how one of Johnny Depp's witnesses, I think Ben Rottenborn, was questioning him and said, this doesn't even say Johnny Depp's name. And the witness said, well, what other husband did she have 2 years ago that she's accused of domestic violence? So if you didn't have something like saying that, then no, I don't think you'd be successful in a defamation claim.
If you were to be approached by the press because they knew about the litigation, because it is potentially accessible to the press, and they ask you questions, and you have a really famous partner that is the abuser, is it safer to say, I can't talk to you? I can't answer your questions about what happened?
So are we in the middle of the TRO litigation or are we after?
After. Because Amber was well after.
Okay.
Right?
It's always safer to not say anything. But if I'm understanding the hypothetical, it's that she filed for the TRO 2 years ago. Then 2 years later, the press approaches her to ask about...
When Johnny Depp beat you, tell me what happened, or did he?
If she's answering it, then she's publishing the statement. Okay. Publishing in the air quotes for what that means legally by saying, yeah, he did. Then that's.
What if this is the what if game? What if she were at a party and she's a little drunk and her friend is secretly recording her? Not as a malicious thing, and Amber Heard is telling a story about how Johnny Depp beat her, and that person publishes it. Is Amber Heard liable for that?
I don't think so. I'm not super up to date with every defamation case decision that's ever come down. But to me, again, you're not intentionally publicizing anything in order to cause damage to this person. That is the friend that is doing it. And so if you're just telling some person, your friend, I don't think that rises to the level of defamation. Maybe other attorneys would disagree with me on that, but I don't think so.
Yeah, I mean, it certainly wouldn't make sense. So if you lied and said, hey, take a video of me and claim that you did it secretly and post it, and in that state, it's actually not illegal to privately record someone and post it, and then you could get your story out. I'm just trying.
I mean, maybe. I suppose you could. I don't know how any person would prove that this was acting in concert and that you were actually the agent authorized to do this for the supposed victim. I mean, in theory, it's kind of what happened with Johnny Depp and Adam Waldman. What the jury found happened with Adam Waldman. I mean, it wasn't Johnny Depp who said those things, but they thought that Adam Waldman was authorized to do that. So if there was some proof that they knew about, that supposed victim told friend to do this, then it's the same thing.
I don't know if you saw what I was hypothesizing, and I don't even know if this was Adam Waldman. When Elaine was cross-examining Dr. Curry, Elaine was saying, did you not make this statement that this lawyer for Johnny Depp had made this statement saying that Dr. Curry... Yeah, I don't know what the term was, but the claim was that Dr. Curry, prior to evaluating Amber Heard, had claimed that she was borderline and abusive, and the lawyer said that Dr. Curry said that. And I was hypothesizing, because I've been there before, where a lawyer or a police officer, investigator, will ask me questions, and I answer without knowing what's happening, and I don't heavily caveat it with, and by the way, when I say I don't know, but I would hypothesize, I'm literally saying I don't know and just saying this could be true. So don't repeat. But if I don't say that, then people will take the statements and kind of mold it to their goals. And then the attorney, this is all just me just hypothesizing, and you, of course, I'm guessing you would be hypothesizing too, but just let me know if this is possible, that the lawyer goes after the Amber Heard team and says, you better settle or agree to all of our terms because we have this, this ace in the hole of Dr. Curry who has already blasted you. And the attorney has no idea what they're doing because they don't understand that the other attorneys are going to go like, well, Dr. Curry has never evaluated Amber Heard, so you're stupid for even talking about this. It's not intimidating. There's no grounds for you or Dr. Curry at this point. I was reading between the lines a lot. Do you think that's possible?
It's possible. What I think is more likely, just having done expert disclosures in the past, again, without seeing what was actually written, it's hard to know if it was just the typical run-of-the-mill thing. What we usually say is, Dr. Curry is credentials. She is expected to testify about whatever. When I heard what they had said that it says about cluster B personality disorders, that sounded bad to me. It sounded bad that they had written that she's expected to testify that this before she had ever looked at the records. So I think that was not great on the attorney's part to say that. But you trade expert disclosures. It's part of the whole discovery schedule that you have. You have to turn in, like, here's our supposed expert witness, and this is what they're going to testify to, or what we expect them to testify to. So that, in that sense, I don't think it was anything nefarious or trying to influence the other side into settling. Do I think it was not great to do it that way? Yeah, I think it would have been better if they had just said, Dr. Curry is expected to testify as to Amber Heard's whatever.
Okay, so let's kind of rip through these last number of questions, speed round, because I want to get to all of them before we adjourn here. Sharon from Edmonton says, did Johnny Depp fans in the courtroom affect the jury's verdict?
Well, they weren't exactly wearing Johnny Depp shirts or Captain Jack Sparrow costumes. Judge Ascarati was very clear that the gallery members were not allowed to be doing anything that might influence the jury. The couple of YouTube lawyers who were in the room a lot of the days said it was really hard to read the jury at all. They were pretty stone-faced the entire time, but to my knowledge, the gallery was pretty quiet most of the time. There was some giggling a little bit with some answers that Johnny Depp had, But for the most part, it seemed as though, and the jury wasn't there afterwards when Johnny Depp would get up and leave and wave, and everyone would wave at him. So impossible to know. Do I think it would have affected them? No, not really. When you have when you have to balance these little things with all of the testimony that they heard and the pictures that they saw, I just don't see something like that outweighing all of this other stuff that they're seeing.
Listener Alicia says, how could Amber Heard have had a stronger case with the evidence that she had? Like, if you were on the team, knowing, what would you have done differently?
I would have her say a lot less than she did. I don't think she had to say 14 instances of domestic violence. Maybe she had to say something about sexual assault since that was in the headline. But to me, it would have been so much more convincing if she just said, yeah, he would push me and scream at me, and he slapped me sometimes, and it was a horrible, toxic relationship, and I felt scared, etc. That's enough, I think, to win that case. And again, it's hard to disprove a negative that he never, ever did it, but that would have been credible, possibly. Everything she said was basically not credible. So does that answer the question? I think that just paring everything back a lot would have been a much better strategy.
Okay. Patron Kendra from Dayton says, since evidence clearly showed at least verbal abuse, we already asked that question. Ken says, what part of Amber's testimony did you stop believing her? So at what point you're watching and you're like, oh, I don't think this is true?
Her demeanor really impacted me. So when she started talking and gesturing, maybe this was part of it. I never saw any tears. I saw a lot of crying. I didn't see a single tear. It really looked like she was trying hard to do it. And then the acting coach comes out and says she has a really hard time doing tears on demand. So she just looked like she was faking it to me. So I don't know that there was a specific point where that story doesn't sound right. It was, it was just
Was it right
her.
off the bat? Because, when she first starts with her testimony, she talks about her childhood.
Yeah, that was all fine.
Okay.
Yeah.
So when she starts to recount the alleged abuse and the emotions that she felt, that's when it looked fake.
I do remember, now that I'm thinking back, I do remember the time. It's the first instance of abuse that she recounts, the wino thing, where he smacks her allegedly and she falls on the floor all of a sudden. And then she talks about, all I could think about was this dirty carpet and how did we get such a dirty carpet? And to me, that sounded like something you would hear in a Lifetime movie or in a novel, and not something a person actually thinks about, remembers, and decides to testify to. And then same incident, she gets out to her car and she's leaning against it for a long time before she can drive away, and she can see her breath on the window of the car. And again, that probably actually was it for me. It just sounded, I actually Googled the words after that to see if it actually was. I wasn't thinking the Talented Mr. Ripley thing, but I'm like, this has to be in an article somewhere that somebody wrote about in like Elle magazine. Couldn't find it, but it just sounded so fictitious to me.
Interesting. Yeah, I remember when I was hearing that story, I remember thinking it didn't really add up. From my memory, her story was that she looks at his tattoo and it says wino, and she inquires about it, or she laughs a little bit like, oh, ha, it's as wino. And then he just hauls off and hits her. And I'm like, okay, is there any corroborating evidence? Have we shown a pattern that he did that kind of thing?
Yeah.
And then in his testimony, he was talking about how it's a sensitive issue for him because his tattoos are like a journal, and he has a tattoo of his son and a tattoo of Winona Ryder that he changed into wino, and it's a part of his life, and he's not trying to, shove it in her face because it was literally 30 years ago that he was with Winona Ryder. And given that, and then that later audio we hear where she's just cackling at him, we could maybe match that up and say that she was cackling at him. Who knows? But she says she was just innocently laughing, and that maybe not violence happened, but at the very least it doesn't sound credible the way she said it. Now, I'll tell you, if someone just told me that story and I didn't know anything about them, I would tend to believe them because people don't tend to lie about those kinds of things.
Yeah.
But when we take all the other evidence into account, you're just like, it just doesn't fit. It's possible, but it just doesn't fit.
Yeah, it's the whole thing is a very uncomfortable, and I know for you especially, but a very uncomfortable position to be in just going into this trial. I don't think I've ever seen a Johnny Depp movie, honestly. I had assumed,
oh, really?
Yeah, I don't think so. So I knew nothing about them. I knew nothing about Amber Heard. I remember hearing about this a few years ago. And then I heard something about Johnny Depp like over Christmas. And I thought we canceled Johnny Depp because he's an abuser. And I never would have expected someone would make all of this up. I'm just definitely a person who would, why would someone lie about this? We want to believe people. We want to think they won't make this up. So it felt really weird to move from one side to the other.
Yeah. And to me, my safe place is that her testimony was so hard to believe. It wasn't in the gray zone. There were these clear stories that she told in elaborate detail, the beatings and to unconsciousness, and then she shows a picture. There's that other one, the other moment when she had that bruise on her arm, and she takes a picture of that, and her face is in the picture, and she claims that that was the next day after being beaten in the face over and over and over to unconsciousness for hours, and there isn't a scratch on her face, and she can't claim that she's trying to hide it because she's literally documenting the bruise on her arm.
Yeah.
And so I'm like, how does that make and then the other incident with the finger, she takes pictures of the writing on the wall.
Two pictures for all of Australia. She only did the mirror. Ben King, I think, did the one, took the pictures of the walls. Yeah. She said she only took those 2 pictures of the mirror.
Right.
It just, you can't, that doesn't make any sense. Right. Why you would not. That's
if there were no pictures, then it'd be like,
if there were no pictures, then again, you can't, it's very hard to prove a negative, but then, yeah, because maybe he smacked me and there wasn't anything to take a picture of. If she had nothing, that would have been more believable to me.
Yeah, but she had pictures that she was clearly documenting his actions and nothing.
It did not match.
Yeah. Outside of Amber Heard's testimony, what testimony do you think had the most impact?
I mean, Johnny Depp's probably. That would be my guess.
Why? How do you think he came across? We haven't really talked about your take on his testimony.
I mean, again, it's hard to know if I'm viewing this through a bias now, but I thought he came across as pretty believable for the most part. I know that you think that he probably understated his substance use, which is probably true. I know a lot of people have said the UK judge found that to be a reason why he was just not credible at all. And so maybe that's why he was underplaying it. But just the stories of what happened that he told made much more sense than what she was saying. I mean, it's just, I went to hide in the bathroom. She wouldn't let me go away from a fight. She had to keep engaging me. It made sense. It fit with the recordings. So I think he came across probably as pretty believable. I know that the alleged juror said that they discounted, and again, who knows if he's speaking for everybody, that they discounted all of the relatives and the paid experts and employees, that they discounted all of that testimony. So that doesn't leave a lot of other people. It leaves Morgan Tremaine, Morgan Knight, the airport lady whose name I can't remember, who allegedly saw Amber with her prior partner. Can't remember who else there was.
There's a couple of, I don't know if they included her.
Oh, yeah.
The couple therapists, yeah.
I don't know if that included with the paid people. I mean, maybe Dr. Kipper and the nurses counted as paid people, but
don't you think that's a little unusual that they just discounted all of that testimony? Because some of it, there was some of it where I was like, the bodyguards seem like they would be really chummy with Johnny Depp, particularly his current employed bodyguards. But that one house worker, I don't know what her role was, but when the mineral spirits and
Yeah.
they're coming
From
down the stairs. Like, it didn't seem like she would. Well, I don't know. Maybe she would, but it's interesting that they would discount
like
the
it was
whole
just
thing.
too matter of fact the way she was telling it. Like,
Right.
So again, who knows if this person speaks for everyone or if he meant literally every single one of them.
Or maybe he meant we took it into consideration, but there were questions as to the credibility based on where it was coming from.
That maybe that was just not the thumb on the scale for either side.
Right.
But in terms of Dr. Anderson, who was the couples therapist, I can't say what the jury thought, but to me, she seemed like she had no bias in either way. She had no reason to be not telling the truth that I can think of. And she comes out and says she thought Amber initiates it most of the time.
And took pride in initiating it.
Yeah. It was the biggest fear, the thing she was most scared of was him like leaving a fight and leaving her or abandoning her. And so she would do anything to keep him there. And she said she definitely initiated it. Well, to the extent she knows, but I guess Amber admitted it to her that she initiated some of the time. And she said she thought Johnny Depp initiated it, less so. But she said, but on that, I'm less sure. So I thought that was pretty powerful, all in all.
Yeah. Petra asks, why can't experts look at their notes? If I were on the jury, I would want accurate knowledge instead of I don't know. That's their question. And of course, you and I went back and forth a little bit about this because I was screaming in my reaction videos, like, just let her look at her goddamn report. I mean, it's 25 pages, you know. And you and Attorney Craig were like, well, actually, da-da-da. So can you explain that in briefly?
Yeah. So witnesses aren't allowed to have cheat sheets. Generally speaking, I mean, no witnesses. You want them to be testifying from their memory and their personal knowledge. It makes more sense, I suppose, for fact witnesses, because you don't want them to be able to get their story straight with what they said prior. Expert witnesses, there might be less of a concern about that. They were only brought in for the purposes of litigation. But all you have to do is, if the witness says, I can't remember, the attorney asks, would it refresh your recollection to look at your report? And the witness says yes. And you walk up and you hand the witness the report. And then they look at it and attorney says, does that refresh your recollection as to blah, blah, blah? And she says, yes, this is the answer. And that's all you do. The report does not become evidence. It does not go in evidence, but she's allowed to look at it. If you can't remember, it's refreshed recollection. It's an exception to the hearsay.
Why didn't they do that? Because it seemed like they did let Dr. Hughes do that kind of, but they didn't think to do that with Dr. Craig.
Really. Dr. Hughes just brought it up there on her own and whipped it out. It was very bizarre. I've never seen that happen where a person or an expert just brings their own stuff up and says, oh, it's just a Post-it note. But like, you just don't do that. That was very weird. So I don't know that they let her do it. They just made it work. Like, after the fact, they sort of said, oh, do you need this to refresh your recollection? But it's not supposed to come from the witness on your own before you've just laid that foundation. I'm not sure why that's an actual rule like that, but I guess you got to have rules on how you do things.
So last few details here. One, I did a poll with the listeners and the viewers on YouTube as to whether or not they thought the verdict was fair. And we got a lot of people responding to the poll. And, well, let me ask you. So I asked people, yes, sort of, don't know, and no. What percentage do you think said yes or sort of that the verdict was fair? What's your guess?
Oh, what do I guess?
So this would be people that are viewers on YouTube and my fans.
Right, I know. I see what the comments say on your videos. So I would guess there were more people that said they thought it was fair than not.
True, that's true. What percentage do you think said yes, and what percentage do you think said sort of?
I would guess like 65% would say yes, they thought it was fair.
It's close, good. Yes, 56%.
That's lower. I mean, obviously, that's actually lower than what I thought, but that is... It doesn't seem like 56% of people on your comment section. It seems like way more than that were pro Johnny Depp.
Yeah, and then 19% said sort of, so that amounts to about 75% think it was, you know, at the very
Sort of there.
at least, yeah. And 13% said they didn't know, and only 12% said no, it was not fair.
Okay.
Now, you know, in the comments section, people will say, look, you know, I don't agree with your kind of take on the situation, but I'm here for your expert opinion about it. So it's not like I'm, you know, annoying people. And I kind of like that. I was actually worried that I was only going to get people that agreed with the verdict, but I like the fact that someone could watch my content and think that Amber Heard was innocent, or that she was not guilty of defamation or liable of defamation, and still tolerate what I say. The next question kind of has to do with this, but someone submitted this. It was an anonymous listener, and I wasn't really going to ask you this question, but I thought I would, because I think some people actually want to know the answer to this question, including myself, which is, how can we, meaning the listeners, how can we deal with people who are harassing and bullying Dr. Honda?
So when you're saying harassing and bullying, you're not defining that as the people who are just saying, you're so biased.
No, yeah, that's fine. People can say, I'm stupid, I'm biased. I've been on the internet doing stuff for 14 years, and people saying I'm stupid, that's a regular part of my life. It hurts my feelings, but what scares the crap out of me is people, maybe not necessarily in the comments section, but in other arenas that people make me aware of, where I don't want to go into specifics, but are actually trying to harm me. They're getting together as a group to actually get me in a variety of ways that they can attempt on the internet or in other ways. And that's scary to me and my wife. I mean, it's just us in my house. And so it just makes me terrified, you know?
I mean, yeah, I would probably call the police.
What if it wasn't criminal? And some of it is, but what if it's spreading lies and trying to attack my profession? I don't think I would ever do anything, but at least this anonymous listener, and I guess I'm a little curious as to what at least the options are.
I mean, that is defamation. So theory, you could sue them. I mean, you could have a lawyer send a cease and desist. That's usually what I would think would be the first line of doing. You have to know how to contact them to be able to do that. What
if you can't? What if it's just a username that you don't have the a clear ability to contact them directly?
I mean, there have been people, Congress people, who go after, this is not the same situation, but who go after people who are critical of him on Twitter and sue them in Virginia, oddly enough, with like a John Doe name. And then they give a subpoena to Twitter to say, give me the actual identity of who this user is, because I need to be suing them for defamation. So, I mean, that's one legal route you can go. It's an awful lot of work to be doing that.
Based on your demeanor, it doesn't make the congressperson look good, right?
The congressperson already doesn't look good. Yeah. I mean, it's ridiculous. Okay, spoiler alert. Don't know if you'll want to air this, but it's Devin Nunes in California. He sued an account called Devin's Cow, who I follow on Twitter, and Devin Nunes's mom. It's ridiculous. Like, they just made comments on Twitter. It's a cow account. So it's like, come on. So he sues them, and it does sound ridiculous. So yours is a little different, but the reason I just know that this is a thing you can do is because I followed that litigation.
Yeah, I mean, I'm mostly just waiting for the trial to be over and people will just stop paying attention to me as much, and I can go back to my fans who have already been self-selected as people who are at least like-minded enough.
Yeah, I think that the law, in terms of either on the civil side or the criminal side, hasn't very much caught up yet with the developments with social media and just how things change in terms of how you defame people or how you threaten people. I think the law hasn't caught up yet with that. So the options are trickier.
Yeah. I mean, to me, just to close it out, the options are to do nothing, which is, I think, what I'm going to do, which is what I typically do. And I rarely regret if ever, doing nothing in situations like this. It always feels like I should do something, and then a year later, I don't regret not having done anything, Or if I did something, I would actually just try to reach out to them directly and just be like, so would you like to talk? Because if you just want to tell me how you feel, like I'm willing to listen. We might not agree about things, but, or two, the kind of things you're saying about me, you can disagree with me. You could think I'm an idiot, but those other claims, I just have to say they're just not even true. And it hurts my feelings, and that doesn't usually work. I always think it will for some stupid reason, and that's another reason why I usually don't do anything, because it's just a double hurt that you try to be vulnerable and nice and reach out, and then they just double down, and it's just more evidence that the person just has no empathy for you at all. And it's the last question. Peely asks, is it illegal to poop in the bed?
Oh, wow. Well, if it's your own bed or somebody else's bed, I guess is the question.
That's the best lawyer initial response I've ever heard.
Yeah, I think I'll leave it at that. You can do whatever you want with your own bed. I guess a person could say it's an intentional infliction of emotional distress, but if you're doing it with someone else's bed, that's a clear no-no. But it's your bed. Go for it.
Oh, Allison, one very last question. What have I been saying about legal stuff that is wrong that you want to tell me about? Because I'm sure I'm saying some stupid things.
Well, the thing that pops to mind right now, because I think you just talked about it, was very, very technical legal concept of the bruise kit. The bruise kit thing, you thought maybe it's just... The bruise kit thing was not a mistake, because there are things that are actually sold called bruise kits. Or bruise wheel. You can Google it, look at it on Amazon. It is for theater makeup to put bruises on. The Milani palette that her counsel showed, which we now know wasn't available back in whenever that was, is not theater makeup. It was a lie.
What do you mean? I'm confused. What exactly was the lie?
Okay, so she said, this is how I covered up my bruises. I started with foundation, and then I put on concealer, and then I used my bruise kit. Oh, it wasn't a bruise kit. It was a theater makeup kit, a color correcting kit. No, she was right the first time. It was a bruise kit, because even if she misspoke on calling it a bruise kit, I called it a bruise kit. What she was saying it was, the color correction thing, is not theater makeup. The bruise kit is theater makeup. So that was just a very small thing, but I haven't heard anyone talking about that. What I have heard a lot of people talking about who are women or who use makeup is that you would never, ever put color corrector on top of foundation and concealer. It goes on the bottom. That is just something you know.
So I'm completely lost in the landscape, but I think what you're saying is that the way she even described it, it sounds like she put foundation on and then she put a bruise on top of that. Is that what you're saying?
So I think she made a mistake. I think she meant to be describing how she was covering up the supposed bruise, but she actually described how she put the bruise on. Because, so say you had a real bruise, the way you would do it is you would use a color corrector and put that on first, and then you would put foundation on or concealer, and then you would put on top of that concealer, foundation powder. You put the color corrector on first. She said you put it on last. You don't want orange sticking out on top of your other makeup. So that was just wrong.
And might have indicated that she accidentally revealed her process.
I think it was a real Freudian slip. I think she, just went out of her script for a minute and was just thinking about what she actually did. And she went in that order because she was putting on a bruise. And then just what she called it, the bruise kit, she tried to take that back, fine. But then she said what she used was a theater makeup kit, which it's not if you're just using regular makeup color corrector, which is what she held up to the jury. What she held up to the jury was not theater makeup. Bruise kits are theater makeup. So there was just a few things that were in a row wrong.
So when you were watching that, you're just thinking, wait, what? Did she just
There were
reveal her
immediate
process?
comments wherever I was watching, dozens and dozens of comments saying the exact same thing. Well, saying at least that you would never put it in that order. You would never put it on in that order. And catching the bruise kit thing. I haven't heard anyone say the theater makeup thing, but that's absolutely right. So that was just a minor thing, but I thought people needed to know this, because if you don't wear makeup, you wouldn't know this.
All right, Attorney Allison, this has been amazing. I feel like I've learned so much. I feel, I don't know, more grounded somehow after your explanation, because there's so many questions, and I know a lot of the people are having, listeners are having questions too, and because it just feels so scary or untethered or uncertain, but the way you contextualize everything, I just feel like, oh, okay, the world still makes sense.
Yeah.
That the worries that might be born from the trial, a lot of them are a little overblown, and we still live in a fair world where the legal system makes sense, and we're still able to come forward if we are victimized, and you just have to immediately contact a lawyer and make sure that you don't, make any steps that could get you in trouble later. You just make sure you get proper legal counsel and just be careful. But you can absolutely get safe. You can go to the authorities. Yes. You can obviously talk to your friends. You can talk to your therapist. Just make sure you talk with a lawyer before you publish something about a famous person.
Yeah. Yeah.
And you could still do that. Plenty of people publish things about Harvey Weinstein and Bill Cosby, and they were not sued for defamation because they had enough reason to believe that they wouldn't be found liable. So we still live in a fair, just world for victims. And okay.
I hope so. Yep. I think so.
Well, thanks, Allison, for joining me. And everyone out there, please take care of yourself. Allison, why should people take care of themselves?
Because they deserve it. They really, really do.